as an opportunity within 14 business days to respond. And typically what that means for me is I communicate, once I'm put on notice that a complaint has been received, I communicate with the chair of that board or commission or committee and try to gather some information from the chair. If there are individual members who are named as the parties who violated the law, I will communicate with that member or those members to try to get information. I'll review things like meeting minutes. In a community like Lunenburg, many of your meetings are televised, so I have the advantage of getting onto YouTube and reviewing portions of minutes, portions of meetings rather, which are of some assistance in addition to the minutes. And then I review any other documentation that might be either attached to the complaint or that I might get my hands on that would give me additional information about the topics that are raised in the complaint. And then once I've done that, I will put together a draft response and I get onto an agenda, preferably within 14 business days as the statute requires, to address the proposed response. And that response can essentially take one of two forms. Either it can be an acknowledgement that there has been a violation, and in instances where there's an acknowledgement that there's been a violation, there is suggested remedial action, which is action that the board or commission or committee can take that would remediate the flaw, the violation. Or it can take the form of simply stating that I don't believe there has been a violation based upon my familiarity with the open meeting law and the facts that I've been able to gather. So that's the process that I followed with both of the complaints that are on your agenda tonight. And so and when I prepare a response, I generally don't circulate the response in advance to members of the board or commission or committee, because that just sort of is ripe for an additional open meeting law violation. If I'm speaking to multiple members of a committee or commission, and then take that information, input it into a document and circulate it, I'm essentially circulating opinions of the board members, opinions of the commissioners. So it's a challenge, but so is the open meeting law. So I've got multiple copies here of a prepared draft response. This draft response is not in final form, not intended to be in final form. It is subject to a vote of the commission tonight, and prior to a vote, any amendments that you see fit to add to the document. So let me provide copies to everybody, and then we can sort of walk through it. So, just there.
Thank you.
Sure.
Joe, do you need to announce my presence?
Joan's here.
I'm here.
We'll go back if you have public comment after this. If you don't have one, we'll skip it.
So I'll give you a moment if you'd like to read it. I know it's.
You don't want to read it out loud?
I
Just kidding. You don't have to.
And you want to address both complaints separately, or?
I do, and I'll walk through this so I can get some feedback from the members for sure. And there are, of course, multiple issues within each of the complaints that are raised, so I'll address each of the issues.
Adam, do you know everybody?
already at the table by any chance?
I'm Joan
I think so, yeah.
Introduce
I
you.
feel like I know you because I watched some of your meetings.
John Reynolds
Hi, all right.
and Troy Daniels, Joan Pease, Carl, our minute taker Jane Ranley, and Joe. So, you know,
Thanks.
okay, sorry about that.
That's okay.
Do you have an extra copy of this?
I think I have brought exactly the right number of copies. I think I made 8 copies, so this is all that I have, I'm sorry.
And the complainant doesn't get a copy?
I'm happy to provide the complainant with a copy of my copy when I'm done. I just didn't, I made 8 copies and wasn't sure exactly how many we needed for tonight, so, but I'm happy to relinquish mine over. It's a draft document being provided at an open meeting, so it's a public document, so there's no harm. I don't have to collect them afterwards the way that I would with an executive session or anything like that, so that's it. Happy to keep your copies afterwards and happy to relinquish mine. Okay, so if everybody's done reading, let me sort of walk through some of the issues that were raised in the complaint and how I've attempted to address them. And again, I just preface it by saying it's based upon the information that I got. It used to be that the board or commission or committee had no obligation to meet subsequent to the receipt of an open meeting law complaint. But they've made it now a requirement that within 14 business days, you do exactly that. You meet to consider the response. And I think the intention here is there's an acknowledgement that there needs to be a discussion amongst the commission of the issues that were raised and of an appropriate response. And so I crafted based upon the discussion with the chair, a discussion with those who are alleged to have committed the wrongdoing, but then it's certainly subject to other opinions, other perspectives, and ultimately a majority vote of the commission as to how we go about responding. So Mr. Ebersol raised a series of different violations in his description in the open meeting law complaint form. Some a bit vague, just stating that there have been numerous violations over a period of several months, but then providing some specificity as to what those violations have been. So one violation, or I guess it's sort of a group of violations, and I address it as such, is the forwarding of emails. Emails that were received primarily from Mr. Locke that were sent to Barb, and then were forwarded along to, in a couple of instances, to the full commission, to all members of the commission. And there were specifically 2, I'll call them email chains that are specified here. One of them, and I've identified both of these at the bottom of the first page. The first one identified as forward 2/27/18 meeting inputs. And then the second one was entitled meeting attendance for 2/27 meeting. And there was a concern that both of these expressed opinions, expressed the position of a board member, specifically Mr. Luck, and that those, by virtue of them being forwarded to the entirety of the commission, that constituted an open meeting law violation. That's the first grouping of concerns, alleged violations. Then there's this issue with the meeting minutes, and this is sort of twofold. In one respect, there's just a concern that they're not being timely approved. The open meeting law regulations have a standard for approval of meeting minutes. And then there's a concern about exchanges of emails, again, with revisions, proposed additions or subtractions to the meeting minutes. And so I've attempted to address each of those in that fashion. So taking the first one first, these emails that were circulated, my opinion, and I've stated it here, is that by the plain letter of the law, this does technically constitute a violation. It's probably, in my experience, and again, my firm's town council in 15 towns, I do special counsel work in dozens of others, so we see even open meeting law violations almost daily. I would say this is probably the most common of them, because I think that board, commission, committee members, staff members don't recognize that they can actually be used as the term that's used in the open meeting law determination is as a conduit for a violation, as a conduit for deliberation between a quorum of a board. So one individual member has opinions and sends it to a staff member or to one other member, which might be permitted, but then another member circulates it to the entirety of the board or commission. In doing that, even if nobody responds saying, I agree with what Mr. Luck said, that's correct, or I disagree with that, or he's mistaken, it's still a violation. There need not be a response. It still constitutes a violation according to the current case law. This is so much a topic of discussion these days. There's actually a case that's pending at the Supreme Judicial Court addressing the ability of boards and commissions to circulate certain reports in advance of a meeting. So there's no question that if you receive a report, say from a third-party consultant that you've received in advance of a particular meeting, you could circulate it amongst board members, see attached in advance of the meeting. But what about when the report is the consequence of input from an individual member, maybe opinions from an individual member, something that an individual member participated in the preparation of? Technically, under this case law, that's a violation. So there's some question as to whether or not that should be opened up a bit to provide more flexibility. A complaint that I hear often, and I heard it by a couple of you that I spoke with, is just the concern for efficiency. How can we conduct the day-to-day business, the week-to-week business, the month-to-month business when we've got to comply with these standards? And unfortunately, and I say this too often, efficiency isn't the goal of the open meeting law. It's transparency, and often those two concepts go head to head. So anyway, my opinion here is that this is a violation, but then I recommend that curative or remedial action be taken, which is why you'll see I recommended to Barb that it actually be in the agenda tonight, that the topics of those emails be whether you want to read them verbatim or you want to discuss them generally, be something that we get into at tonight's meeting. Again, I defer to the chair and defer to commissioners as to the extent to which discussion is necessary, but certainly a brief recap of the substance of those emails so there's no question as to what they said in an open meeting like we've got tonight would be remedial action, and we would represent that in a letter like this to the complainant. If the complainant chooses to take this the next step would be to file it or to pursue it with the Division of Open Government. The complainant is not obligated to do that, but that's the complainant's choice. Then the Division of Open Government will investigate. That means that I would likely get a call. It means that the chair would likely get a call. It means that anybody named in the complaint would likely get a call. And once that occurs, we'll get an opinion, a determination from the Division of Open Government. And in a case like this, what I typically see is where we're conceding that there's a violation, they'll probably agree with me, because the case law is pretty clear in this case, and then say, but remedial action was taken, and we advise the board that this is a violation, it'll continue to be a violation, to not do this into the future, and any future violations in the same manner will be deemed to be intentional. And then there's a potential for sanctions and such. Once you've been put on notice once, they don't like to put you on notice again. I will say they're somewhat flexible. I know some communities that have gotten the same notice 3 or 4 times without sanctions, but then there are some pretty serious determinations that have been issued where there's repeat offenders. So that's the issue with respect to the forwarding of emails. With respect to meeting minutes, there are 3 dates of meeting minutes: August 15th of 2017, October 3rd of 2017, and January 30th of 2018. And the complaint here is that, in part, that there were revisions made to these minutes through emails, and I've put a footnote on one of these pages that indicates that to the extent that occurred, that's not acceptable. That could be deemed deliberation, particularly if it's among a quorum of the body, if those revisions are being circulated in advance of a meeting. And my recommendation to the commission, and I'll make it again tonight, is make those revisions, but just bring them to the next meeting. I know it's, again, not as efficient. Nobody can review things prior to the meeting, but that's really how it is best done. With respect to the timeliness of approval of the minutes, that's a different question. And I think that by, again, the letter of the law. In 2 instances, you were late in approving minutes, and in 1 instance, you were not late, you approved them on time. The August 15th minutes were approved at your meeting of, February 13th, and your October 3rd meeting minutes were approved at that same meeting of February 13th. So the standard that's in the open meeting law, and it's actually not in the statute itself, it's in the regulations that were adopted by the Division of Open Government that filled in some of the holes in the regulations, state that you have to approve your meeting minutes within the board's next 3 meetings or 30 days, whichever is longer. So in most cases, the 3 meetings will be a longer period of time unless you're meeting on a weekly basis, say. So Barb was kind enough to provide you with a listing of the meetings that you've had, a listing of the meeting minutes when they were completed, and then when they were brought before the board, and then when they were approved. So I reviewed that entire history. And in 2 of these instances, you were late in approving those. I have noted here, and I got this information from Barb when I spoke to her, that there was I think you had a minutes clerk at one point that left. I don't know exactly the timing of that, so I defer to you as to whether I'm correct in saying that that might have been a basis here for some of the delay from the earlier meeting minutes in August and October. With respect to the January 30th, 2018 meeting minutes, those were approved on February 27th, and you only met once between the 30th and the 27th, so that was within the standard under the open meeting law, and there was no violation there. With respect to remedial action, there really isn't any required here because you've already approved the minutes, you just did it late. So again, I've noted that I've put you on notice, I've reminded you of the requirements of the open meeting law, and that you need to be approving these within your next 3 meetings. And again, I know this is a challenge, again, in many communities. There are communities that have a lesser staff than Lunenburg does, and it's challenging if you have staff preparing meeting minutes. I've got one community where I've got one part-time individual who serves as a liaison to 4 different boards. She works about 15 hours a week. I don't know how she gets it all done. So it's a challenge, but that's how I've responded. So I've talked enough. That's what the response says. Certainly happy to take any feedback that the commissioners have and work it into the response subject to a vote.
I'm okay with it, as is. We can go around the table, start with Carl.
Is this more of a I've never seen one of these, so this is a learning experience. Just procedurally, some of the items that were in the complaint are addressed in notes on the bottom, and the rest are buried. And I'm just wondering what differentiates going in the body versus in a note.
There's no clear line in the body versus a note. It sort of depends upon whether it's a clear alleged violation. So I read through 2 or 3 times the paragraph on page 2 of the complaint that summarizes the violations. And again, there are some statements that are broad, which makes it difficult to respond to. A statement that there have been numerous violations over several months, I appreciate that, but how exactly I go about responding to that, I'm not sure. I need some specificity. Some are very specifically identified. I put those in the body. And then in some instances, there were matters that either were not identified with enough clarity that I felt I could really dedicate a whole response to. So for example, the idea of certain meeting minutes that had been edited through emails. It appeared that they were maybe an attachment to one of the email chains that was included here, but it wasn't clear what the allegation was, or who made these changes, when were they made, to whom were they sent. But I still wanted to provide some kind of a response because it's in the complaint, so I put it in the footnote. Similarly, there's an introductory section here that talks about communication between the chair and a member of the Attorney General's office. I communicated with the chair, as I always do in preparing a response, and was told that the chair hadn't spoken to Hannah Rush. And so that's not really relevant at all to the open meeting law complaint, whether he spoke or didn't speak. It's not an open meeting law issue, but it's something that was raised in the complaint, and so I thought it appropriate to drop a footnote and just address it for clarity.
Good, thank you. That makes it clear. Thank you.
Did you address it all?
I'm not sure. We're going around, so I'm going to start with Joan.
Sure.
Yeah, go ahead, please.
Thank you for coming. I want to say, and I know we're televised, that I think everyone on the Sewer Commission has their heart in the right place and is just attempting to work really hard to make things smooth. And I agree with you that I don't think there was any intentional person set out to break open meeting law. And it was inadvertent in an effort to do things well. Having said that, I think it's frustrating for this commission that we all are not on the same page as to actually what the open meeting law regulates in minute behaviors. And so I think that sometimes there is conflict because we have different ideas as to what our legitimate authority is. And so I think that sometimes leads to people feeling different ways about the communications that have occurred, but I don't think they were intentional to break open meeting law at all. My concern, personally as a member of the commission, is that when these types of communications happen, I personally feel that I don't want to break open meeting law. So I can't participate in any email back and forth that's going on because I don't want to break open meeting law. So it limits my ability to participate fully in discussions of the commission. And so that's how I feel. And I feel that it would be great if we could have some clarification on exactly what is the appropriate, legitimate authority we have to communicate outside meetings.
I think
and all that.
It's a good question, but specifically to this response,
Well, I think, I agree it's unintentional. I think it says that in here. Inadvertent is the word I believe used. So I agree with that. And I agree with discussion as remediation. Is that, am I understanding correctly? So I guess I'm participating in the discussion as part of the remediation.
yeah, that'll be next. We'll go over the emails.
And if I could just make one comment in response to that.
Sure.
Just like to say, I recognize, I don't think that you're alone in asking for or desiring greater guidance in open meeting law compliance. We're a bit late in doing it. In fact, we were supposed to have done it on the 13th, but we had an open meeting law training scheduled. Trainings are available regionally on a regular basis. The Division of Open Government sponsors them, but we as a firm provide trainings in the communities we represent. We feel it's a bit more one-on-one, question and answer style format, and gives municipal officials and boards and commission and committee members the opportunity to ask questions about, well, what if this and what if that? Sometimes there are black and white answers, and sometimes the answer is, well, we think that's probably okay, but there's no direct guidance on point, or here's what the AG said in one instance, but here's what they said in another. It's really challenging for the average official to familiarize themselves with every aspect of the law, because you can read the actual statute, it's a few
Yeah, right.
pages. You can read the regulations, it's a few more pages. But then there's hundreds of open meeting law determinations that aren't in an easily searchable format that are on the AG's website. So it's challenging. There are lots of traps for the unwary built into the open meeting law. So we appreciate that, and we're going to try to reschedule that training for sometime in the coming weeks.
And I hope I'm still on target here. If I'm not, let me know. I think that one of the remediations should be that this commission should sit through the open law training together so that we can have a basis that's uniform for going forward.
And I have stated here that I've recommended that the commissioners attend, and that's part of my concluding remarks here.
So I'm saying I agree with you on that,
That's
yes.
good.
I agree it was inadvertent, and I agree that that would be part of a good remedy for us all to attend the same training together, hear the same things, discuss the same things.
Sure.
I agree. Troy?
Well, I guess part of what I wanted to talk about was already addressed, but you've indicated that there was a violation and that my question is we had a response from the chair that said that we've had many allegations, but we're not going to do anything about it until we get a formal complaint.
No, that's not the exact wording.
And that's summarizing exactly. And so I guess my question is how do we address this going forward, and how do we avoid open meeting law violations in the future? And is that addressed in your response to this question?
Sure. So that's a challenging question to answer. How do you avoid open meeting law violations in the future, other than for the individual commissioners to familiarize themselves better with the law? Part of that is reading it and rereading it. Part of that is attending regional open meeting law trainings or local open meeting law trainings when they're available. Certainly, I know that I can't speak for prior council, but I've tried to make myself available with things like office hours, so that if members of boards or commissions or committees have questions, town officials have questions about process, they can come to me, they can sign up for a slot on a monthly basis, and we can have those one-on-one conversations. I saw the reference in the email chain concerning that communication, the remarks made by the chair. I know you have slightly different statements as to what exactly was said, but it's in here verbatim, however it's stated. I didn't address it in the open meeting law response because it in and of itself is not an alleged open meeting law violation. And so that's why I tried to be careful about what I was addressing in the letter and what I wasn't addressing in the letter. And I went through and I highlighted, you can see in my copy, certain statements made within the complaint, and I marked up and flagged certain aspects, certain pages of the response, because a statement by a chair, even if this is what it said, and I'm not saying that it is, I'm not going to address any open meeting law violation until it's brought forward in the formal complaint. Well, technically, the chair isn't required, the board or commission isn't required to address a complaint until it's brought forward to them. Do they have the option of addressing it? Sure. Is their choice to address it or not address it an open meeting law violation? Does it in and of itself implicate the open meeting law in any way? No. And so that's why I didn't address it in the complaint, because it's not really an open meeting law issue. Would I recommend that boards or commissions address open meeting law complaints? I think it's always good to approach the topic openly and to have discussions openly amongst your membership about the open meeting law and how to avoid complaints. And but I, regardless of the community I'm representing, regardless of the board or commission or committee I'm representing, I always defer to the chair, because that's what we do. We defer to the chair as to how meetings are handled and how matters are handled in between meetings.
And I understand and appreciate your comments. At the same time, I'm wondering how that is a response to the complainant.
So I think that I've walked through carefully the different aspects of the complaint.
Yeah, I would say you've done it very carefully.
Yeah, so is there a particular aspect, and I apologize if I'm not fully understanding or appreciating your question, is there an aspect of the complaint, something that was within the description that was provided, that you feel that I've not been responsive to, that I could be better responsive to in the response, in the response letter that I provided?
Yes.
Okay. So, let me read through this again and see what you're highlighting. Okay, so I presume you're referencing, there's a statement here, several times sewer commission members, the town manager, town council, and board of selectmen liaison have advised against emails regarding issues to be discussed at meetings being sent to a quorum. Recommendations have been ignored. Is that the provision that you're referencing that you think I need to be more responsive to?
Yes.
Okay. So, subject to a vote of the board, I'm certainly happy to modify my letter. That's why we have this sort of a review, to try and more directly address that issue. I don't think I'm going to change my stance that my advice would be to address it either very briefly and probably in the context of a footnote, because there isn't an open meeting law violation being alleged here. What's being alleged is that suggestions have been made, advice has been given, that emails regarding issues to be discussed at meetings shouldn't be sent to a quorum, and that those recommendations have been ignored. Okay, so if the Division of Open Government sees that, they're going to say, okay, well, tell me what we're talking about. What are those emails, and how is the recommendation ignored? And then Mr. Ebersol goes on to address exactly that. He says, here's an example. 226, this email was sent. 225, this email was sent. And so those emails I've addressed in the text here. If you'd like me to address in a footnote or address in the text of the letter, just very generally, the fact that, we recognize there's an allegation here that recommendations have previously been ignored. I'm happy to do that. I guess I don't have much to say about it, because ignoring recommendations is not in and of itself a violation. It's the violation that's a violation. But I'm happy to amend to address that if the commission thinks it appropriate. Certainly, it's not my intent to leave anything out. I tried to be comprehensive in the response. In fact, it's a bit lengthier than most of the responses I've drafted. But I thought it was appropriate.
Thank you.
Sure.
I think we all agree that nothing was done intentionally here, and I think we all agree we do need more training. I consider what we're doing right now training. And I think we've all become more cognizant of what we should or shouldn't be doing. And if anyone, any of the commissioners think there's a violation of open meeting law, just we need to bring it up at next commission meeting and discuss it.
I guess my only issue with that is that we got an email saying that there had been many emails about open meeting law violations and that we weren't going to address them unless there was a formal complaint. And that's,
Right.
I believe what I said was
I
we don't have
understand what
to.
you're saying, but I think we are going through a learning process tonight, and I think sitting here talking about this, I would hope that that wouldn't happen again.
so your hope is that we would address them without having to have formal,
As they come up,
without having to have formal complaints.
correct. And if a particular commissioner thinks they haven't been addressed thoroughly enough, then anyone's free to file a complaint.
I would take that one step further. I think we need training, and we need to stop
Oh.
having violations.
Oh,
I mean,
absolutely.
we have had entire meetings to discuss whether or not these issues occur. So I think we need to have training and all be on the same page and function a little more within the legitimate limits of our authority.
I agree, and I think, I feel like I've always been pretty sensitive to open meeting laws. I would not have considered one of the issues brought up here, which is Barbara sending an email out and, everyone responding, okay? It certainly is a learning process. And we all need to be much more cognizant of the concerns in violation of the open meeting laws.
Like I said, I think it's okay. I think we talked about maybe one amendment. Personally, I don't know if the amendment's necessary. I don't think it is. So we can either approve this or amend it. I think take a motion to take the vote to approve, or we can try and amend it.
I move we approve it as drafted.
Anybody second?
I second that.
Any discussions? All in favor? Aye.
Aye.
Troy?
I didn't vote.
Abstaining? Okay. Okay. Let's see. So the remedial action is on this agenda for the next bullet point here. Has everybody seen and read those emails? It was attached to the open meeting law complaint, the actual emails themselves. Basically, Carl had sent some information, an opinion. Obviously, you've probably seen it, it's in the complaint. We just talked about it during the complaint itself, what was said, and what the intentions were, and that it wasn't intentional to be an open meeting law, but we did say we'd talk about it here. I can do one of two things. We can say we're aware of it and we've discussed it, or I can read them. It's up to, I mean, as far as I know everyone read it, but if anyone wants to.
We're talking about the second open meeting law complaint.
No, we're talking about the same one, just the emails themselves that was in the complaint.
The remedial action.
The remedial action, so we need to discuss the email communication received by the commissioners from Barb, but including messages from Commissioner Carl Luck dated on or before February 26, 2018, and addressing topics including meeting minutes from February 13, 2018, survey letter and response form, agenda items for the February 27, 2018 meeting, the FY19 budget, and Tilton Ave sewer installation costs. Those are the subjects that were in the open meeting law that we were trying to talk about today.
And I sort of pointed this out before, but it's important enough to me that I'll reiterate it. When we have our meetings and we come to a consensus or we take a vote at the meeting and we direct actions to go forward, and those actions are altered in any way by an individual outside of the group meeting, I really feel that my rights as a commissioner to participate in those modifications are kind of null and void, because someone else is going and saying, do this, do that, or change this, make a modification. And all those modifications may be just fine and completely accurate, but they have to wait till the next meeting.
Agreed.
And Adam, a minute ago, you said, if I heard you correctly, that, it's hard to do that when you're involved in the day-to-day work. But we're really not involved in the day-to-day work of the sewers in the town of Lunenburg. That is delegated to the DPW. And so we're really a board to make policies for maintenance and policies for money and manage the budget. So I don't think that the emergency of a day-to-day situation really should impact us and cause us to violate open meeting law, because the DPW is taking care of the day-to-day activities of the sewer commission. So if part of the remediation process is to discuss this, I'm discussing my feelings about how I feel that my participation is limited when someone else goes and sends an email or changes, modifies, or adds to decisions we've made outside of the open meetings. And I would like the commission as a whole not to do that. I would like us to work together as a team and a group, and not some of the time, all of the time. Because very rarely have any of these changes that have been proposed in between meetings, very rarely have they been life or death, they have never been life or death situations where if we didn't wait a week, it wouldn't still be able to be addressed. And so I'm asking, if this is the discussion part, I'm asking my colleagues here, can we all work together at the open meetings and bring our ideas to the open meetings where everyone has an opportunity to reflect on them and discuss them, as opposed to saying, well, after the meeting, I found this mistake, I thought of this, I did that, and I can't respond to those because I don't want to break open meeting law.
I fully commit to doing that.
You'll commit to doing that? Thank you. Anybody else?
Absolutely.
That's normal way of doing business.
Well, it hasn't been for our commission. I mean, I know we only have these violations presented, but I feel there, in my opinion, have been other instances where people have added after a meeting, which has modified decisions. And I don't want that to happen anymore. I want us to work in the open meeting forum together as a team, together.
Yeah, I certainly acknowledge and agree, and I think council mentioned before that there are open meeting law violations every day, and every one of us have done it. So I think we can all learn from what you just said.
Did you say that?
I said there are violations every day. Not in Lunenburg.
And you were not referring to the sewer commission. You were not
No,
saying
no.
we've all violated.
No,
Yeah.
I made no statement about anybody violating it. My statement was that open meeting law violations occur with great frequency. It's a very difficult law, and it's contrary to the usual course of business in many respects in some communities for years. It's challenging, but once you become familiar with it and you develop a protocol, it becomes a lot easier to comply.
Yeah.
Maybe not as efficient as everybody would like it to be, but it becomes easier to comply.
And we have to identify internally that none of us are above the regulations or laws. They apply to all of us, no matter how good our intentions are.
Well, and I wouldn't want to minimize the violations by saying that they happen every day either.
Wasn't my intention.
Yeah, no, I'm just stating it for the record.
Just on the, regarding the discussion, to bring it back to focus, I think we're discussing the emails that were specifically identified in the complaint, which was the February 26th and the February 13th emails.
Right.
Right. So just to make it clear, and if I'm wrong, it's a good time to correct me, the emails that I sent to Barb, which were full of opinions, hard for me not to, the act of me sending those emails to Barb was not a violation.
No, we have to put the blame on Barb.
Okay, so just so everybody learned from that, because I don't want anybody to get the impression they can't share something with Barb.
No, and there is often back and forth. So you can share something with Barb. You can share something with council. I get this question often. So the board votes on a decision. I'm then going to draft the decision. And so they give me the charge to draft the decision. I can prepare that decision, and I can send that decision out to all members prior to a meeting. And sometimes I say to individual members, you can hit reply only to me, do not hit reply all, with comments on the decision. That's all well and good. And if I make changes based upon your comments and your comments and your comments, and then I bring that next decision to the final meeting, great. If I make changes based on your comments and your comments and your comments, and then I hit reply all and I send the next version, now I've been the conduit. Now I've committed the open meeting law violation because I've taken all of your opinions and I've worked them into a document that I've circulated, and all of that deliberation occurred outside of an open meeting. So it's real easy to go the one extra step. So no, the step of sending something to Barb doesn't do it, but Barb, in an effort to try and be efficient, make everybody aware of what's going to be on the next meeting agenda, sends it out.
I have a question there. What if Barb acts on that opinion? What if we have a discussion at a meeting, we come up with a consensus, and then someone modifies that consensus just to Barb, says, I don't think that's right, I think we should do it this way instead. And Barb acts on that one person's opinion.
So this is a different issue, and we're going to touch on it, so I don't want to get into it too much with the next complaint. But this is a different issue, and this is an issue that, in fact, doesn't implicate the open meeting law. It's less of an open meeting law issue and more of an issue, and I know it's been an issue for your commission before, because it's been brought to my attention before, of who can act on behalf of the commission. If they're not acting with the authority of a majority vote of a quorum of the commission, who can act?
Exactly.
That's a different question. And generally, only a quorum can act, and you can appoint a member, a commissioner, to act on behalf of and inconsistent with the vote of a quorum, but no member has the authority to act on behalf of the commission, him or herself.
So I just have a question. If we take a vote to do something, and then one member goes to a person who is a town employee and says, hold off on that, I don't want you to do that yet. I want you to wait, because I think we may change our mind. The commission didn't say that, that one member did that. Is that allowed?
It's not supposed to occur, it's not supposed to happen that way. It's very challenging for the third party, because you go to the third party and you say the commission, or maybe you don't even say the commission, but they know you're a commissioner, and you say, hold off on that. They think you're speaking with the authority of the commission, you're a commissioner. They don't know that the commission just voted the previous night to proceed, but you said hold off. It's very hard for that third party to understand who they're supposed to answer to. So it's really incumbent upon the members of a commission, the members of any board, to, when you take a vote, let's do X, okay, Mr. Daniels, you're going to be in charge of doing X, consistent with the vote that we just took, and then nobody else do anything, because you've appointed him as the person that's doing it, and he's acting with that authority to do X per your vote. The better approach is to use someone, if it's day-to-day, someone like Barb, who is not a member of the commission, to carry out the day-to-day on behalf of the commission. But there are those instances where it's better to have somebody who is a commissioner, maybe take certain action, or is volunteering to take the action, which is something we'll get into with the next complaint. But that individual needs to be sure that the action that they're taking is consistent with whatever the vote was. And you really can't put it on the third party to have known what the commission authorized. They just believe that they're doing what that commissioner told them, and they're presuming that that commissioner is acting with the authority of the commission. It's challenging.
Okay, so I appreciate all that. I think,
Can we address the emails, Mr. Chairman?
yeah, it's probably easier that way.
Yeah, I don't want to go into it in great depth, but I think just simply saying you've all read the emails and it's fine sort of obviates the whole purpose of having it in a public session. So I know you've read them. I'm not going to read both of the emails or the chains of emails verbatim, but I'm going to touch upon them just briefly, what they said, the two emails that are the subject of the chief subject of the complaint that we just reviewed. So one of them was an email from Carl to Barb, copying the chair. This was in response to an earlier email chain. The date of the email is February 22nd. It's the one that is entitled Meeting Attendance for the 2/27 meeting. And it says, Barb, I will be there. On the agenda, the items that I feel are important and time sensitive, as we need to get our ducks in line to effectively use or commit funds for fiscal year 18 are, and then there's a list of items 1 through 6. These items are spares, I&I, scope of services and RFP for maintenance plan, budget information requests and preparation and presentation of the plan, Tilton Ave survey, and irrigation meters. Those are the 6 items that were on the agenda. The concern, because it follows in the email chain, was that Mr. Daniels responded with an email to Barb raising concerns about the phrase, quote, I feel important and time sensitive, that was used in Mr. Luck's email. He believed that these are opinions. We've been advised not to share opinions with the commission, to reply all or through you. So again, as you know, my position on this, I agree that by virtue of Barb forwarding it, some of this could be perceived as an opinion. The line is fine. You know, what's an opinion and what's simply a listing of agenda items? I guess I will say I've got maybe somewhat less concern about I feel are important and time sensitive, and maybe some more concern about things that are actual opinions or suggestions. So item 6, irrigation meters, I suggest we appoint a subcommittee to work on this as we need something in place well before the new fiscal year. A fair point. If it was made in an open meeting, no issue. It's a suggestion. Someone like you who receives this might say, well, I don't think there should be a subcommittee. And I'd love to respond and say no, but now this idea of a subcommittee is going to fester for the next week.
That's right.
Until
That's
the
right.
meeting occurs. It was only one day, but for the next.
Right.
And he's got his word in before me. That's an opinion. It's in an email. It went out to the whole commission, not intentionally. You didn't send it to the whole commission, but it made its way to the whole commission. It results in an open meeting law violation. And so that's the issue. So that was one of the emails. The other email was an email that was entitled Forward 2/27/18 Meeting Inputs. This was inputs that were sent by Mr. Luck to Barb, copying the chair. Here are my inputs on the 2:13 minutes, so this one does reference the minutes. Survey letter and response form. As the letter changes are extensive, I felt you should provide a few notes and thoughts to you and/or the sewer commission. I hope you can support most or all of these changes and rationale. And then he goes on to identify notes regarding survey letter. He only sent this to Barb. He copied the chair. That's acceptable, copying the chair, because it's only 2 members of a multi-member, more than 3-member commission, so there's no violation there. But when Barb forwarded it, and it was clear that, and this is partly why I got the intent issue and why I had a conversation with Barb, it didn't appear to me that there was any intention here for it to be a violation. She begins by saying, corrections, concerns, questions for tomorrow's meeting, please do not reply all, which, why would she have said that if she obviously was mindful of the open meeting law? And although some of Carl's points for the letter could be considered his opinion only, it is for the purpose of the commission to be prepared for the discussion. I've included them in the email verbatim. We will discuss these items at a meeting and not over email. Clearly, she was intending to not violate the open meeting law.
She did.
Yeah. A for effort, Bob.
So anyway, those are the 2 emails. The topics that were raised there, again, were changes to the survey letter, changes to the minutes, and that was about it. Some other various opinions that were just referenced in the email, but that's the subject of the open meeting law complaint, and I think that's the remedial action we needed to take, which was to have the discussion in the
Perfect.
open meeting.
Thank you. We did get the extension approval. We received it on 3/19/18. Just wanted to point that out, that was approved. Thank you, Adam, for doing that.
Sure, it's through tomorrow, so I'll get this submitted in final form tomorrow, and I'll send the
Perfect.
commission a copy.
Thank you. We're going to move on to the next open meeting law complaint. Once again, I'll pass it over to you. We can pass those out. We can read them.
Yeah, I will. And again, I apologize because I've got 8 copies here. Should have made a couple more.
Thank you.
I will probably hand over my copy when we're done. Give you a chance to read it, and then when you're done, we'll walk through it the way that we just did with the first one.
All good?
Okay, ready to discuss?
Yeah.
Okay.
Go ahead.
Thanks. So, so this is an open meeting law complaint received from Mr. Daniels, dated March 13th, 2018. So to some extent, I sort of gave you the punchline already. The complaint, and I'll read this one, it's a brief description of the violation. It says, 2 members of a 5-member commission approving and submitting analysis to Kevin Olson and Matt Corbin at Wright Pierce. They said they could do another analysis for $5,000 to $7,000. 2/27/18, Mr. Luck and Mr. Anderson were insistent that only the 2 had approved the analysis, and so the request, the action that's desired is acknowledge the open meeting law violation, avoid open meeting law violations in the future. We've addressed that, and I've stated in the letter that that's the intent and that there's the open meeting law training scheduled, and then acknowledge 2 members cannot act on behalf of a 5-member commission. So my issue here, and I'm careful not to express an opinion on this because I already spoke to it, and it's not really an issue that's properly before the Division of Open Government if the complaint were to be pursued, which is, you know, do these members, did Mr. Luck, did Mr. Anderson have the right to take action on behalf of the commission? Well, that's a question of what was the commission vote? Was there an authorization for either of them to take action or both of them to take action? I reviewed what did exist, which was the tape of that meeting. There was the second meeting, so there were 2 meetings that were implicated here. The first one was the January 30th meeting, I think. That's correct. And that meeting was on YouTube, so I was able to watch that meeting and watch the relevant portion of it. The second meeting, which is when I guess you all came back and you talked about the matter further, was not a televised meeting, so I wasn't able to watch any portion of that, and I wasn't obviously in attendance at the meeting. So I haven't spoken on the issue or opined on the issue of whether that was appropriate, because it's not an issue that implicates the open meeting law. The action by 2 members, to the extent that there was action by 2 members, some of the facts indicate that the action was primarily by Mr. Locke. There was this one email exchange where he got sort of a go for it from the chair. But to the extent that there was action by 2 members of the commission, you can see here that I've stated on the second page, action by 2 members of a 5-member commission, whether it's sanctioned or unsanctioned, doesn't implicate the open meeting law. The open meeting law deals with meetings. Meetings are deliberations by a public body with respect to matters within its jurisdiction. Deliberations are an oral or written communication between or amongst a quorum of the body. In this case, the quorum is more than 2 individuals, because a quorum is generally a simple majority of the members of the body. So we're not dealing with action by a quorum. Whether it was sanctioned or not the issue. It's the issue of whether it was a violation of the open meeting law. I did want to address, and I did it in the following paragraph, maybe didn't need to, but I wanted to be clear, there is this concept of a subcommittee. It's something that is referenced at the very end of the definition of a meeting in the open meeting law, and really not referenced anywhere else. But there's this concept that a board or commission or committee can appoint a subcommittee, usually in a formal manner, but sometimes less formal, and that subcommittee could then itself be subject to the open meeting law. So you've got to be mindful of that. So the question became, did the commission take any action to officially appoint the subcommittee? I didn't see any action to that effect on the video from January 30th. There was nothing in the meeting minutes. There was some question as to what authorization was given exactly. Certainly, Mr. Luck was at the center of part of that discussion and was very explicit in stating that he volunteered to do some of the research that was necessary. The vote that was taken didn't expressly say that Mr. Luck was authorized to do that, but both before and after the vote, he was speaking about how he'd be doing it. Again, this goes to whether he had the authority to act on behalf of the commission. I didn't speak to that in the response because doesn't implicate the open meeting law. And so this was a simpler one because the topic was more pointed, but that's the substance of my response. So again, this is subject to review by the full commission, vote of the commission, so I welcome individual comments and revisions. I'm happy to modify it as necessary.
Okay, we'll go around the table again. I agree with the response, and I like it. I don't think we should change anything. That's all I have. Carl?
Yeah, I think it's accurate and fine. I assume that Exhibit C is the February 1st email?
It is, yeah, I didn't attach the exhibits, but yes, that's correct.
Joan?
I was only at the video meeting. I was absent for the next meeting, so I can't really say what happened at that meeting because I wasn't at it and there was no videotape of it. So
The February 13th meeting?
yeah, I was not at that meeting.
Is the February 13th meeting in the actual complaint itself?
I don't think that it was referenced in the complaint, but
Okay.
it was the substance of the issue.
It says alleged violation date, February 13th.
That was the email that I sent.
Oh,
It was
I
on
see.
February 13th.
Right. It says Mr. Luck and Mr. Anderson were insistent that only the two had approved the analysis. So that's what caused me to look at the next meeting, because, well, when were they insistent? Because the question of the approval, when was it given, was the January 30th meeting.
Oh, no, I was present for that discussion.
Yeah.
It happened at the following meeting that
Right.
is on YouTube.
That,
Yes, that happened, because I missed a meeting where you discussed Tilson, and then we were going over the minutes.
Correct.
Of the meeting that you were speaking of that we do not have a videotape of.
yes.
And during that discussion, where we were looking at the minutes, that is where the discussion occurred about who gave who authority.
Okay. So
And
it was
there is a
the-
videotape of that.
Okay, that's fine. So I didn't look ahead to the next meeting because the next meeting
It would
wasn't
be
there.
on the next meeting.
Next meeting, okay, so that'd be the February 27th. meeting.
Yes.
And we
That
tabled,
was-
and we tabled the discussion in general.
But it was quite lengthy discussion.
Okay, so I should reference that.
Probably should look at that.
But, Mr. Chairman, the discussion at that meeting was about what actually happened at the meeting.
It was what
the subject
happened.
meeting, at
It was
the
what
at the
happened in the-
televised meeting.
It was what happened in the email.
No, it's what happened at the previous meeting, which was
No,
not
it was,
televised.
it was who gave authority to talk to Wright Pierce during the
I
email.
didn't
That's
go
what it
to
was.
that middle meeting, so I can't really comment.
That's okay, I'm
on
just
that.
saying in general, the discussion we're having right now, and the question, we were looking at the minutes, Carl had edited saying that I gave him permission to talk to Wright Pierce. We were arguing that, was that an open meeting law violation or not? That's what the big discussion was, and that's why we tabled it. And that's what's being responded to here, that it was not an open meeting law violation, because that's what the
Yeah.
complaint was.
And I wasn't at that middle meeting, so I
That's
feel
okay.
like I can't really comment on that.
Yeah, I mean, the complaint itself, I believe, is more about that email saying, go for it to Carl. But yeah.
So I'm passing.
You want to say anything? John?
I'm happy with the response with the additional reference to the meeting. But I just, maybe this is an aside, but I think we just need to be a little more careful when we give someone marching orders as to a project, because I left the January 30th meeting under the impression that Carl was going to take that, investigate it. If he had called Weston and Sampson, even without talking to you, I would have been fine with that, so.
Yeah, the email was basically, I'm going to talk to Weston and Sampson unless Joe says not to. And I responded, yeah, just go for it.
Wright Pierce.
Wright Pierce, I'm sorry, Wright Pierce. So, sorry, John, sorry to cut you off. You have any?
Sorry,
Good.
So maybe to that point, and I was going to say before, but there seems to be a lot of discussion about it. In here, there's a part of that February 1st email, and I can't find the darn email here, or I'd read it, but you might want to include the whole sentence after where it says, unless you say not to. And if you have attachment C here, maybe.
I do.
Because after I said that, I referred to the fact that I believe that I had been given that charter by the commission,
Right, yeah.
but I
you
was
did say that.
basically looking for confirmation that,
And I think that's
To
in
still
the
go
minutes
do
that
that.
you edited that are
I
for
think Exhibit C
approval
is
tonight.
the,
So I've got the documents here. So the exhibit, which is the email that says it's from Mr. Anderson to Mr. Luck, go for it, Carl, thank you. That email
So
chain
nice.
began with an email from Mr. Luck that stated it was to Audra, who I presume is somebody with.
She's on the Tilton Ave.
She was the Tilton Ave
Okay.
resident.
And the last paragraph of that email stated, Joe, unless you say not to, given my charge from the commission, that the statement that you're
Yes,
indicating?
right.
Okay. I may contact Wright Pierce in advance of our meeting, so I will add that statement in.
Perfect.
That's fine.
I'll entertain a motion to approve that response
With those modifications.
with those modifications that we just talked about. Thank you, Adam.
I would move we approve this response as modified.
Anybody second?
second.
Any further discussion? All in favor? Aye.
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 And abstain?
Yeah, I didn't vote.
Okay. That takes care of both open meeting law complaints.
Thanks for
I
your
think
time.
you have more time on the second one anyway, I believe, right? I don't know how much time you have when you
I
do
do,
this.
yeah, we're within our 14 days, but I'll respond to both of them tomorrow.
Really appreciate it, Adam. Thank you so
Thank you.
much.
Thank you, nice to have met you.
Yes, same here.
Hopefully, we don't have to talk on Friday nights anymore.
And you said there's going to be a reschedule of that open meeting law training?
We're still working on it. We've had some challenges because we've tossed around a number of dates, but some boards, some commissions, some committees meeting on every night we seem to choose, and the goal is to get as many people there as possible. So we're gonna find the time to do it.
Awesome, thank you, look forward to it. I'm just gonna real quick go back to the board public comment now that Joan's here. Joan, did you have any public comment that you wanted to say?
Sorry, I was late.
It's fine. How you feeling? You better?
Oh, and that is the public comment I wish to make. I am still on recovering, and I'm
sorry to hear
told it'll take at least a month
Oh,
to get full
gosh.
energy back. So if I start feeling poorly, I will be exiting, and it will have nothing to do with what is happening at the meeting. I will hang on as long as I can.
It's fine.
But,
Why don't you just give us an end time?
Yeah, we should send that. That's a
I will-
good idea.
To the end. I'm not contagious anymore. I've been on antibiotics for 10 days.
Okay.
So,
Well, I appreciate you being here, and of course, if you have to leave, absolutely leave, but hopefully you
I
get
just
better
didn't want you to
soon.
think if I leave, there was,
No, Joan, I don't think anyone here thinks you'd do something quietly. If you had a problem, you'd announce it. All right, we're gonna go to,
We have one more public here that might want to, if you want to, I don't know.
sure, yeah, come on.
In a public comment mode.
Well, it's in board public comment mode, but come on up.
I'm sorry. Dan Proctor. I was just curious if there was any progress.
Yes.
Okay.
And I didn't, I am ready to do it. Actually, Mr. Costa was holding hostage my final agreement of the restitution. I have it now.
Okay.
I have a check. So it will be coming out to you.
You actually have the check already?
I do.
Jeez, all right.
There you go. Perfect.
I didn't know if the next step was going to.
No. I was trying to get
Okay.
both of them together and get it to you.
Great.
And I'm not sure if I missed it earlier, what happened with the extension on Tilton Ave, that vote, did that come up already?
It's coming up next. We have it on here, but if we can, we can
just
talk, it
curious.
wasn't, it was not 2/3, so
Okay.
it was no for now, so I'm sure Audra and you can talk about it after.
Exactly. Okay, thank you very much. Thanks, Bob.
Thanks.
All right.
Okay, we're gonna go into the FY19 budget. FinCom presentation, discusses of changes to approve budget, stabilization funds, and Fitchburg rate increase. So we had the FinCom presentation. I talked for about 30 seconds, and Carl did the rest. So Carl, thank you very much, by the way. First off,
You're very welcome.
Carl found some things that we needed to be fixed. It wasn't it was more of a math problem. We had some math issues on the original budget. I just want to make it clear that during the FinCom, Carl did say that he presented what we voted on, saying that it was going to change. He didn't, Carl didn't change anything or anything like that during the presentation. He did state several different times that, it might change depending on what the commission wants, things like that. It wasn't saying this is going to change, we're going to do this. It was more of a, this is going to change, possibly depending on what the commission wants to do. We'll see what happens. And presented what he could, and I think he did a great job with what he discovered and what he did. So thank you very much, Carl, for that. I look forward to you doing it again next year. So let's just keep going. So with that, I'm gonna pass it over to you, Carl, if you don't mind, and you can kind of go over some of the stuff you found, and we'll talk about it.
Well, I could just summarize where the issue was, and then Barb could tell you what's in front of you here. Basically, what happened to us, we had about, up in line items 3A and B up here, on the night we reviewed it, the three of us, I guess, John, Joe, and myself, we had about $39,000 of revenue up there. That was really not revenue, it was transfers from retained earnings. So it wasn't new income, it was income we had. So although we worked really hard to make it balance and still have a capital,
Right, I remember
that we came up short.
And what was the deficit?
Including the capital transfer of 22, it would have been about $39,000 at that point. However, Barb has gone away and come up with this, which basically I think Barb is, we now have a very high confidence that the 30% that we had put in for the Fitchburg rate increase won't happen. They're going to, it's not done, so there's always
Yeah,
risk.
They're meeting tonight.
But they're only presenting I think, percent increase to the council.
They're meeting tonight?
As a matter of fact,
What are you doing here?
it probably, well, it's Fitchburg Council. Last meeting that they had, they were going to present a 10% increase. And they had some pre-meetings with counselors to get the the whole thing. It ended up, I guess, being talked into 10% was still a little high for the council, and so now they're down at 8, which means in year 2 and 3, it's 9 and 11, or what, it's going to ramp up now instead of other options. But for our current situation, it works, because Barb has gone back here and taken that and come up with a new calculation, which is, maybe you could explain, Barb, where this piece of paper is, and then we can discuss what to do.
Right, so everything, yes, so everything was the same from what was presented. It was just that it was coming from retained earnings retained earnings, I&I and reserve capacity, income from previous years. So now it is current, and we've reduced the Fitchburg usage.
Yep, see it?
204. It was,
Yep,
I believe, around-
204,191.
And then the indirects, actually from conversations with Karen on the indirect cost, discovered a formula error, and Karen has fixed it. So that did save the commission about 6,000. So those two reductions together really took care of most of our deficit. We remain actually to the plus of 8,500. It's up to the commission whether we put that 8,500, add it to that Fitchburg usage line, because we're not sure. Or if you want to have that overage be there, and the intent is to reduce our transfer from retained earnings for the betterment income deficit. That's a conversation.
Mr. Chairman, I have a proposal for discussion on that. When we started this process, we were going to try to stick to the capital reserve of 3%, which was $29,000. We got the break even by making it $22,000.
Right.
I'd like to propose that we take 7 of that 8,000 and put the capital reserve back to 3% and leave the rest just where it is, just as a whole $1,000 cushion.
I agreed, and when you speak of the capital reserve, Carl, that's the money some of that is the money we spoke of for doing a study, an engineering study on the age of the pumps, how long they're going to last, and a plan for...
No.
No.
That wouldn't be, in my opinion, it's up to the commission, that wouldn't be an appropriate use for capital.
Well,
that would come out of
Okay.
Capital is more purchasing.
out of our
those.
engineering services and things.
So capital is not
Capital
more
would be
purchasing those
a
spares.
large
and,
person,
like, purchasing those pumps.
Yeah.
Once
like
we
that.
decide the age.
Right. So the
Planning for
engineering is
purchasing.
different.
Okay, that's...
Yeah.
Yes.
Yes.
So it's just,
That's what you meant.
That's what I meant.
Yes.
That's what I
literally for
meant.
capital, for buying
Right,
things.
that's
Yeah.
what I meant. I meant for starting to plan to replace things that are getting old, that are going to wear out. We don't want to wait until they
Right.
wear out.
So we buy stuff.
We buy stuff.
And we use that capital
We
fund.
plan ahead to have money to replace those.
Got it.
And is that in line with what was recommended by the FinCom of taking one-time fees and applying them towards capital?
That was a subject that was brought up by Mark Erickson at
Yeah.
FinCom, that because connection fees are a one-time type revenue, that we could use that line in the future for that capital line. But may I say what my feeling was on that?
Of course.
For right now, just in this whole startup of this commission, and the monies that we need in order to operate, we have needed those connection fees to keep us trying to balance a budget.
Great.
I think it's.
So we're
I do think it's-
keeping our rates artificially low because we're keeping them low from income that is not going to repeat. is,
The rates
I'm
are
not saying
low.
it doesn't,
yeah,
it
no, I
can't be
just,
done.
I just want to make, I just want everybody out there to know that, that we're, that instead of a rate increase of incrementally, that there could be a rate increase that is substantial all at one time, based on the way that we're,
This would be up to the commission to do this in
Yeah.
any method that they want.
Based on what we know right now,
based on what we know, and based on what could happen, are two different things.
Yeah, but it was a suggestion.
But
And-
go-
and-
well,
I
to
would
begin
say-
with, our rates aren't artificially low. They're probably some of the highest in the state, and which is why I'm so determined not to increase them. In terms of the comment by FinCom, there were a couple of comments, and that was one, and it works this year because we have about a $33,000 one-time out of connection fees. So you could, rationalize.
So we didn't agree with Mark's
If I could explain.
comment.
If we could just.
If I could
Do
finish
we agree with
speaking.
Mark, or no?
If I could,
I'd hear what Carl
I'd like
says
to know
without-
if we
without
agree with
interruptions.
Mark or not.
Okay, well, after he's done, we can stop interrupting. After he's done, we can talk about it.
So you could say that this year, that one-time income is pretty close to what we're setting aside, which is what Mark did say, and I said, it's a good point. What he also said is that we really should, and he supported, we really should have some financial policies on, in the budgeting. right?
Yeah, I agree.
So that we, like they do,
About
so that we use
financial
one-time
policy.
money or whatever. So I think that's one of the things we should be addressing this year before the next, well, in advance of the next budget cycle. We have an unofficial one we've now done, or will when we take a vote, 3% of revenue for the capital fund. We've never really made that a formal policy. We should have that discussion and see if we want to make that a formal policy or not. And I think some other policies would be good to get down. I mean, even the definition of what we call break even would be good to get down, because people come and go on these commissions, and if we don't, have something that retains the knowledge that we've developed and to keep us going in the same direction, unless there's a conscious decision to turn. So I think there's a lot of things on our financial planning that we should go forward with, and there was another one that Mark or someone mentioned. I can't think of it off the top of my head now, but I'll try to make some notes of those suggestions. Can't remember what the other one was, sorry.
I think those are both great suggestions.
As far as determining financial policies, I think that should be a discussion that happens sooner rather than
Yeah, I have it on,
later.
to add it to an agenda soon.
So we agreed with Mark, or we didn't agree with Mark?
Which
Commission.
comment?
For the one-time fees that come in, that we apply them to capital?
Well, I can only
The
speak for
fees that don't
myself since we
repeat.
haven't discussed it, so I can't say we agreed to anything.
Oh, okay. All right, well,
I
good to
think
know.
that-
I thought
I think I'm
based
trying to
on the
address
meeting
your- trying to answer your question.
that I was in attendance for, and the agreement that was at a meeting, I thought there was agreement. But I
Carl
guess
didn't
not.
agree to anything, actually, throughout the whole
We
presentation.
don't know.
Well, he stated that many times, that his opinion, but not the opinion of the commission. He said it
Yeah.
many times.
Yeah.
So he didn't agree to anything.
I think the concept is
I
good.
think it's good to state for the record that we don't agree to anything.
That's not what I said, but you can say whatever you want.
I thought that's what you just
I
said.
said he did not agree to anything.
You
at the
didn't agree to
FinCom-
anything, okay.
At the FinCom meeting, he did not
Right.
agree to anything. He stated his opinion and said clearly that it was not the opinion of all the commission,
Great.
that he would have to bring it to us.
Thanks for the clarification.
You're welcome.
Which, Mr. Chairman, I find quite interesting, since Mr. Daniels was the only person at the meeting who really knew it, so it's rather disturbing to have all this disruption over this.
I'm sorry that my participation is considered a disruption.
Me too.
Okay, let's just move on here. So we have this new budget here. We need to vote on it. First, Carl wants to move the, well, what was the exact figure going back in the capital, please?
Yeah, I'd like to make a motion.
For you, if you want.
Did you want
The
to?
3%?
Do you want to make it? Yeah.
I know, somebody said what was the amount. It was
Oh,
8,000.
I just like to make the motion, that we increase the transfer from our revenues from into the capital reserve account from $22,000 to $29,000.
Right. So it was 7,000, not 8,000.
Yes, yeah, we had 22,
Okay.
and the 29 just happens to work out within a couple bucks, the 3% of the revenue.
Give it a second.
I would second that.
Discussion? All in favor?
Aye.
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 Troy?
I didn't vote.
Okay, abstain. All right. So this is now the final, well, we'll go to FinCom, correct? Maybe other changes. This is, with Carl's change, Barb, this is ready to go?
Ready.
Do we need a vote on the approval of the entire thing?
Yes, because my motion was only relative
Just
to
for that, yeah,
the
just for that one line, so-
stabilization fund. right?
If I can get a motion to,
I make a motion, we approve the budget with that. I don't have to say, because that other change is already
It's
approved.
already
right? Approve the budget as we have it right now.
Second that.
discussions? All in favor?
Aye.
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 Troy abstaining? Is that a yes? You're abstaining?
Yeah.
Where's my regular agenda? I get lost on these things. Let's see. So that was the budget.
Mr. Chairman,
Capital reserve.
just on the budget, there's a couple more loose ends.
Yep, I'm reading them.
Oh, I thought you said
OPEB.
that was the budget.
No, I'm just, 'cause my working agenda, I don't know exactly what this one says. So we did the FY19 budget, that was this. Capital reserve, we just did that. OPEB, this is the next one.
Yeah, and it's just to advise, I think we brought it up at the FinCom meeting, but that the town is treating that OPEB as a complete fund. The sewer portion will be a sub-fund of the same. So we will not have that article coming from the commission for town meeting.
Right.
It is accomplishing the same thing, but it'll be taken care of with the town article.
Okay. Tilton Ave,
So, Mr. Chairman, just because there's another article relevant.
I think we have, that's,
Oh, okay. we have
oh, I'm
separate-
reading the wrong
no,
thing, I'm
no, we got
sorry.
a separate one.
FinCom presentation, discuss some change, approved budget, stabilization funds. We did,
That was the
that's what
capital.
we, yep.
That
And
was all.
Fitchburg rate increase, we kind of touched on it a little bit. We're expecting it's not going to happen, okay.
Got to hear from you.
Sorry.
So we're going to move on to the Tilton Ave update.
Yep.
Survey results, we had the results, you guys all got them. It was not 2/3 of the street. Audra is aware of it. I don't know if we need to really go into detail exactly what the survey was. Audra Sprague and Graham can go ahead and, we're still going to bring the warrant, we'll talk about that in a second, but they're going to have to go ahead and figure out the private and stuff like that. So that was just, this line item was merely just to talk about what the results were, and the results were that did not get the 2/3.
3 yeses and 8 nos.
Yes, correct. So close.
Mr. Chairman, the impressive thing to me was that on such short notice, everybody responded.
Everyone responded. Well, I will,
Unheard of.
I will say it was impressive to see that the Spriggs, their effort to get the message out there. I know it didn't go the way they wanted it to, but they were advocating and going door to door and things like that. So they really did try.
explains
Yeah, yeah. That's why everyone responded. It was probably more of a we have to respond. Or Roger's going to know we need to respond.
There you go.
She really did try hard.
Good. Good for her.
Yeah. Okay, town meeting warrant articles. This is where I was just, FY19 budget, that's, let me just see here what I have. So we have 5 placeholders that were submitted on 3/22. The proposed 6th article was rescinded due to the concerns for the open meeting law and can be done at the fall town meeting. I believe, is the fall town meeting definite, or is that part of the charter review?
No, actually, I can bring that up. That was a conversation with the town accountant when we were discussing that we had these line items. And it was her recommendation that the stabilization fund transfers that we had done in the past should be done at fall town meeting once a year has closed. And numbers are finalized. And it makes much more sense, because when we were trying to do it, we came up with a figure in January. By late April, when we're trying to get motions together, it was like a bubble. So this makes much more sense to reserve them or transfer them after the year has closed.
Just one thing, and that'll be much cleaner, because even when we started going through one of these, I think it was the capacity or something. Because of the confusion, it wasn't working out that easily. Karen had good track of everything, but it wasn't clear where it was. So that'll be a much better process. I would like to say, though, that part of the reason that we had talked to Karen about adding another warrant article, we need to be sensitive to, because last year, out of the capacity stabilization fund, we expected that this year we were going to have to start paying Fitchburg. So we transferred $10,200 and some odd dollars out of the stabilization fund into us to use. We're not going to use it this year. I'm convinced, and as far as we know, but we have some control, and every day that goes by that Fitchburg hasn't even given us what they promised John and I to give us for data, makes it more certain that we will not pay this year. But what we do need to be careful of is, because we now have in our operating funds this year $10,000 plus that is really belongs in the capacity stabilization fund. The purpose of that article was to put it back. That article is not on the table anymore. So in the fall, we need to put everything back, what we've collected up till the end of this year, as well as that 10,000 back into that stabilization fund. So the transfer will include the 10,000 from this year. And the reason I want to sensitize everybody to is we got to make sure we don't spend it. So it needs to fall back into retained earnings. We don't spend it, it'll fall back into retained earnings. And then when we make this transfer of roughly $19,000 plus in the fall, that 10,000 will come back out of retained earnings and go where it belongs and follow the rest of the fees we've been collecting.
Okay.
And you'll hold us to that, Barbara?
Yeah, she will, absolutely. OPEB article number 3 will be combined with town's OPEB article. I think you just touched on that. Vote to remove the 5th article, what is this, for Tilton Ave?
The 5th article went in because we hadn't received the survey and met in time to talk about the fact that we will not be going, assuming the commission will not be going to town meeting to request appropriation for a sewer project to do.
So there is still an article to add Tilton Ave to the sewer use.
That had to be submitted because we hadn't met. So I just wanted it on the,
So if we remove Article 5,
We still have Article 4.
Article 4 is still, yeah, so
Yeah,
we're
so
still in there.
Article 4 still covers
It's
it.
just that there will not be a project without.
Yeah.
That would allow them to move forward on their own if they
Okay.
choose.
Okay, thank you. All right.
But are we talking about removing it or just passing over it at town meeting?
Passing over.
Okay.
But it's
Passing
just
over it.
that
Yep.
We
Okay.
need to let Heather know that that's.
And we need a vote to make sure that we can,
I mean, they
we all
may be
agree.
still able to remove it, I don't know, to tell you the
Right.
truth.
Right,
Well,
but
let's
we
make
need
a,
vote.
so what should the motion, should it be to remove or to pass over?
I think you have to cover both that.
Pass over?
Remove if possible, or pass over.
Right.
I move that we vote to remove Article 5 if it's not too late, or pass it over if it's goes to town meeting.
Second.
Any further discussion on that? All in favor? Aye.
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 Troy, you abstaining?
Aye, sorry,
Thank you.
I seconded it.
I know. Would have been a first. Minutes. 2/13/18. This is one we tabled.
Can I make a comment here
For the minutes?
about minutes?
About the minutes on the agenda, or just minutes in general?
Minutes in general. Very quick comment.
Sure.
At the last meeting, I really liked what you did, Joe, where you just took the minutes, and especially since the attorney said we shouldn't be sending them out ahead of time with revisions, where you just read through them and said, anybody got a problem with this paragraph? I felt that was efficient, quick, and I actually felt it was quicker than the way we've been doing it, where we discuss forever. So I'm advocating that we do that.
That's fine, yeah, I mean, it probably is a little bit quicker. So why don't we start with the 2/13, so we do have, yeah, do we have,
We have 213, it was in our packet,
yeah, that's with Carl's edits, right?
yeah, that's with Carl's edits. We
You guys
should
have Carl's
original.
edits, okay. Okay, so I'll just run through the edits real quick, and we can talk about them. First edit is Joe opened the meeting at 6:32. He crossed out stating that in accordance with open meeting law. Yeah, that's fine. The next one is he crossed out drain on the side of road. So drain on the side of, so basically it will stay on the side of the road. instead of drain on the side of it. I don't think that's a big deal. Anybody disagree there? Okay. The sewer commission had a workshop. For the outcome was that it may be possible to remove this area from the map and keep the capacity in reserve. So that was added. And then we took away to take study area 4 out of the sewer service area. That was just kind of a clarification thing. I agree with that change there. If it's silent, I'm just going to keep going, assuming no one has a problem. With the okay of the sewer commission chairman, Carl sent his analysis to Kevin Olson. That's what we just talked about. Said they could do another analysis for 5,000 to 7,000. That was their response. We just talked about all that stuff at the open meeting law, so I say just keep it in there. To submit a warrant article to add, the addition here is just submit a warrant article 2. That's just, again, clarifying. Down below, we have, where's the start of that sentence? Commission discussed how to offset increases in Fitchburg and Leominster rates and options for the issues with irrigation meters, including implementing a $50 a year meter fee to the addition was to offset meter reading costs and other administrative costs unique to irrigation meter users, 80 out of 800 customers, which was discussed and agreed. I believe that to be accurate as well. They just added a word further in the second sentence, and then, so it reads now, the commission agreed to further discuss irrigation meter fees and problems at a future meeting. Again, we talked about minutes. Let's see down here. Carl stated that opinions that are stated in the meeting are okay to have in the minutes. So if they are opinions discussed in there. And what's this down here?
Those are adding
This is just-
handouts or documents that were discussed at a meeting that just added to the bottom of the minutes.
So review document with attached prepared by Carl Luck and Tilton Ave, follow up on resident request for Tilton Ave to be added to sewer service area. Okay. So those were the edits.
Yeah, just that last one, just so people, and we haven't historically been good at this, and it's tough, I'm sure Jane will help us, but any documents that we use at the meeting are supposed to be noted in the minutes
Fair enough.
and available in the file.
Thank you. Take a motion to approve these.
I did not attend that meeting, so.
Sound like a motion.
I make a motion to accept the minutes for the 213. I make a motion to accept the minutes for 213 as amended, as noted in the minutes.
Second?
Any further discussion? All in favor? Aye?
Aye.
Aye.
I'll abstain because I wasn't at the meeting.
Fair enough.
Aye.
Okay. Minutes for 2/27/18.
Now, these are unedited minutes, correct?
Yes, but
Okay.
I have received edits today, which I didn't send out.
Good for you.
Nice job.
We're not going to.
I think I told you to.
I'm like, no,
Bob's like, should I send these out? I'm like, yeah, sure, send them.
Is that a test?
I'm glad she
it was a
did.
test.
Can you pass them around?
Yes.
And we'll do, they're humongous, Carl, really?
Well, we should really, Joe.
You should get paid for
may I
this.
make I don't think we should be looking at the amended minutes. I think we should go through the minutes without prejudice, just as they're written, and then people can say, I would like to amend this paragraph. Instead of taking one person.
How about this? I'll do you one. Did everybody read the unamended 2/27/18 meetings? Everybody read those minutes?
Yes.
Unamended, yeah.
Did anybody have any changes?
Yes.
Carl did, so here we go. So that kind of covers that. If you had changes.
Okay, we can do either way.
Well, I mean, I don't want to sit and go through, no offense, I don't want to sit and go through every single thing on the minutes. If everyone read the minutes and don't have any changes, and one person does, we'll go through those changes. They're already prepared. Do you have changes for the minutes?
No, but I might, if somebody else said, I think this paragraph missed this, I might say, oh, yeah, you're right, they
Right.
did.
But they-
So
so-
that could, I think it's quick when you just do it. We could probably be done already.
I think we are done. I don't know if I missed your point or
I
not.
guess you missed my point. For instance, if John said, well, wait a minute, in this paragraph, I'd like this change, and I don't see it here because we don't have anybody's ahead of time, and I was like, oh my God, John, I didn't think of that. That's a really good idea. We should put that in there.
That's what I just did. I said, does anybody have any changes to the minutes? Everybody said no.
Carl said yes.
Carl said yes, but
Oh, I see
everybody
what you're
else,
saying.
everybody else said
Everybody
no.
at that point
So
should've
at that
said
point is
okay.
if you had
I get
changes,
it.
you go ahead
I get
and
it.
bring
A little
them.
slow on the uptake, sorry.
It's fine, you're going through a whole lot.
I understand.
And I talk way too fast sometimes. Okay, so let's go through Carl's, that's not actually that bad. Maybe it's just because the
No, it's
font
not
is
many.
bigger.
I mean, a couple of them are questions. I mean, the first one, under appointments, the 6:30, and Jane probably has this right, but did we not take a vote at the first appointment with Proctor's?
No, we took the vote before, it was just to sign the piece of
We did
paper.
just sign?
vote a long
Okay.
time ago, yeah.
So you had a motion on here, need motion and vote should include the amount, so we're gonna cross that out. Yeah, that's not gonna.
That's not a, I mean, these things are just comments, they're not,
And then the next thing was small water systems.
we did take a vote there, though,
We
right?
did.
We took a vote to
Fund the,
Fund it.
fund the,
I believe I voted
I thought-
against the motion is not necessary. That doesn't,
I think the vote was for task one, not for,
no, we funded the
No, we
spares.
funded the replacement parts, Joe. We took a vote to fund the replacement parts.
I wasn't at the meeting, but watched it, and, I mean, I was left with the assumption that you voted to fund.
Yeah.
We did, we
Yeah.
took a vote, it was
Yeah.
3-1.
I think so. If we didn't, I'd be happy to discuss it again.
Further down.
it is in here. I know, I
Down
thought it
there?
was, yeah, I thought,
Was it
I don't-
further down? Can
wasn't
we go
when-
back to it?
It wasn't during the appointment.
Oh,
Okay,
it was-
all right,
it was
good,
afterwards,
good,
that's
okay.
right.
That's, I knew Jane
It
would
was
straighten me
when
out.
Jack came up
Great.
with
it.
So those are just questions, and
Thank you, Jane.
Jane just answered them.
Somebody was on my side, that's nice. Nice change of pace here.
So what are we doing?
I believe we're
We're crossing that one
moving
out.
on.
We're removing,
We're moving
cross
on.
that off and
Yep.
we're moving?
Yep.
Okay.
Public comment, he added in, complaint of violation of local meeting law for the business manager distributing information containing a member's opinions. That's fine, I can't, that's not, and then there was no discussion, right? It was just stated, and then I said moving on, and we moved on. Current business added was, it was decided not to go through with the questions. Jack stated that he had given the questions to Weston Sampson, that they said that this drilling down was going to expand the scope of work. Carl noted that there were other manholes that had higher cost-effectiveness values that should be considered. Carl, maybe you can touch on that a little bit.
Well, I went, I spent too much time today looking at YouTubes, and those are, certainly what Jack stated is the exact words. And I think it's important.
current business.
Current
business,
DPW, yeah, DPW.
Can you read Carl's thing again, because you went kind of fast. for me.
Yep, so he added, it was decided not to go through with the questions. Jack stated that he had given the questions to Weston Sampson, and that they said that this drilling down was going to expand the scope of work.
You know, I don't think we need to put all that detail in the minutes. I absolutely don't.
I strongly disagree, because I think it's a important statement by one of our suppliers, and it's not a good statement, and we should,
Well, let's take a
We
vote. Do
should
we really want to
acknowledge it.
put drill-down statements like that in our
well,
minutes?
but that was said, that was a quote from Jack,
Well, we
that our,
need to vote on the minutes on what we want, you know, we're not saying it wasn't.
So we're
said.
saying there's contention on this
Yeah.
change. I'm going to move on to the rest of the changes. I did start that one, we'll bring it up. Discussion, Carl brought up concerns about fundamental problems and very big flaws in the RFQ. I don't think very big flaws is appropriate there, Carl,
No,
to
I
be
don't
honest.
either.
it's a quote.
Yeah, we're not saying
can
it
put it in
wasn't
quotes.
said at the meeting. We're just saying that the minutes don't need to have every quote that every person at the meeting
Well,
had.
clearly doesn't have every quote of every meeting.
I know, but.
No, but so hold on a second. So Carl brought up concerns about fundamental problems and quote, stated that he believes there are very big flaws. Would that make more sense? If it's your quote and opinion, that the very big flaws is obviously an opinion. So
But
I don't have a problem with you putting a quote in there, but we need to make it clear that it wasn't, that your opinion is that they're very big flaws. But I don't know if we even need, I really don't know if we
I
need
don't
that in
think we
there.
need it in there. I think that we're getting ridiculous.
Yeah, you brought up concerns about problems in the RFQ. I don't know if we need fundamental and very big flaws. I definitely don't want very big flaws in
No,
there.
I don't either.
So I'll star that.
Well, I guess that would beg the question, why don't we want what was actually said in there? Why are we sensitive
'Cause it was
to
'cause it
putting in
wasn't- it
writing
wasn't-
what was actually said?
It's not, the minutes are not a transcript of the meeting.
Obviously.
I believe that because of your edits, you're trying to make them a transcript of what you said, Carl. And I think it's too much. None of the rest of us do that. We have discussions at the meetings, And the minutes summarize the gist. They're not a transcript. A transcript is different than a summary minutes.
It's not intended to be a transcript, it's intended to capture what's
Yeah, I think we're
important and
gonna-
relevant.
Yeah,
And
let's-
if you disagree, then we don't, we put it in, that's
Yeah, I
all.
think
You're talking about leaving the word fundamental in.
No, we're talking about the
No.
very big, fundamental and very big flaws are the two
So you're talking
changes.
about taking
Yeah.
both out?
Yes.
I think that Carl brought up concerns about problems in the RFQ was fine enough.
Yeah, I don't have a problem with that in there. That states
Personally.
his position on it.
But we haven't voted on it yet, so let's keep going. And then incomplete for 130 minutes as
Actually,
amended.
there's stuff on there's a page 2.
Yeah, discussion on,
Carl, I'm not sure you saw that there was another page 2.
Yeah, I didn't, thank you. I did, it was so far down.
Those changes off?
Well, the only on the, that stuff goes away.
Okay.
so these two changes.
Way down, yeah, those were again questions as I just didn't understand because I didn't know that a page and a half later was the rest of the minutes. And the only thing I did, proposing is that on the second motion that was made relative to, on that last page, there was a motion made, as noted, and then there was some discussion, and then there's another motion. I just put revised in front of motion because it was a revised motion.
All right. Where is that? I'm sorry.
It's not on this,
Well,
it's not
wait.
on ours.
What?
I don't see it on
To
ours.
accept the minutes for 1:30:18 as originally submitted, discussion, Carl, Joan withdrew her motion and made a new motion. So revised motion, Joan P.
That was what I suggested.
So revised, right.
Just to stick revised in front of motion. Put revised in there, because
Yeah.
same thing as this motion.
Yeah, okay, so
That's fine.
revised
It's
motion.
if it's declared, if it makes it clear, that's fine. So I'm gonna go through real quick. We're removing the first edit on the 6:30 appointment. We're removing the edit on the 6:45 appointment. I believe we're keeping in the business manager distributing information containing member opinions. There was no discussion or staying in. Removing, it was decided not to go through the questions, that whole sentence there. Removing fundamental and very big flaws, and then adding revised on that motion on page 2.
So we're removing the decided not to go through the questions? That
Yeah.
whole- Okay.
Unless somebody, well, let's take a motion to,
I make
What I
a
just
motion to
said.
do what Joe just said.
Second.
okay, so we can have more discussion. I obviously, I agree with what I just said as well, but if you want to talk about it, Carl, you'd be the only one who wants to talk about it, I believe.
I don't want to talk about it, I just want to state that it's disturbing and troubling that I don't understand why the commission has sensitivity to things that are factual and I think are significant. I think when a supplier does not want to entertain questions from the commission on our RFP, I think that's significant and worthy of being captured in the minutes. I don't know what the commission is afraid of putting down what is actually said in the meeting.
I can
So, there.
accept the fact that it's important to you, and I think one of the beauties of democracy is we get to vote, because when all of us view everything through our own filter, we always put our own twist on it. And so by having a group vote, you tend to remove individual filters, and you tend to get a more cleaner approach because you have multiple eyes looking at the same thing.
My main problem with that sentence is Carl noted that there were other manholes that higher cost-effectiveness values that should be considered. The Jack quote and the quote of Weston and Sampson I didn't really have too much of a problem with. But I also don't have a problem with removing the whole thing either.
I think it should be removed. If thus I made the motion, and thus we have a second.
Any other
so.
discussions about the motion? All in favor?
I'd like,
Aye.
Sorry. You got it in there. What was it?
I'd like to amend the motion and have it leave the sentence, it was decided not to go through the question. Jack stated that, the rest of that sentence.
It was,
I'd like-
you're amending it to keep in,
To leave
it was
in.
decided not to go through with questions. Jack stated that he had given the questions to Weston Sampson, and they said this drilling down was going to expand the scope of work. That's what you're,
That's my proposed amendment.
okay? Anybody want to second that amendment? All right. All in favor of
My
Joe's original
amendment.
motion?
Except him as Joe went through. and took
Aye.
this. Aye.
I guess I have to abstain, I wasn't there.
No.
Okay. Okay, town charter review. You have the draft. I did watch the 228 meeting today where they touched on our section. I don't know if you guys, I'm not gonna go through this entire thing.
I read it
Let's go to
carefully.
section 314 and talk about our stuff.
If I can find it. Do we have any more?
It's actually
copies?
section 313 now, as the
Barbara, do you have any more copies?
draft gets
by
rid
any
of town
chance?
clerk.
The charter
Yes.
changes? No, I did not.
Okay, I did read them.
I brought the memo that I did not include in the original. It
I
does
read
not.
them at home. I just don't know if I have them.
I can read them. It's not a whole lot, so I can go ahead and read it if you want. Why don't I do that anyway? The first change is just changing Board of Selectmen to Select Board. That's riddled throughout the entire charter. It's not just our, that's what they're proposing either way. So,
Which I think is a good change.
yeah, I don't have an opinion on it here or there.
Yeah, well, I
It's
mean,
not a bad change to
it
to change
recognizes that we have women that serve on
We
the,
sure do.
so
And I know a lot of towns are doing that as well, so by
So-
all means.
Mr. Chairman, I don't know if we're going to go through the whole charter or
No,
just
we're not.
stuff relative to
So-
us,
but that is
however,
relative to our spot.
the select persons,
Select Board?
which was just commented on. So since it's been commented on, I'd like to also make a public comment that I don't think it's a good solution. I think it's putting the town through a lot of work and a lot of aggravation and going to have a big ripple effect through all our documents for nothing other than a politically sensitive thing. I don't think anyone objects to being called human or mankind or congressman or anything else. And I know for a fact, and it was stated in the Charter Commission meeting, that none of our female selectmen mind that term. So I'm not in favor of it. But I suggest going forward, we just focus on sewer commission items.
Yes, let's go ahead and go forward. So here's a change, and this is probably the most lengthy of them. So this is talking about relating to intergovernmental agreements concerning sanitary sewers. The next sentence is provided, however, that nothing in this section shall be construed to authorize any member of the commissioners nor a majority of such members to become involved in the day-to-day administration of the commission. Let's just touch on that sentence real quick. So provided, however, that nothing in this section shall be construed to authorize any member of the commissioners, nor a majority of such members, to become involved in the day-to-day administration of the commission. So I believe what that is saying is the day-to-day administration of the commission is Barb's responsibility and not ours. I believe that's how I'm reading it. Anybody else reading it somewhere else?
Well, I think that's exactly what it said all along in a different way. I don't think that's really a change.
Right, I think this is just to clarify.
I think
It's not to change really a whole lot of
clarification,
stuff.
no change at all.
The next sentence.
I disagree.
You disagree with that?
Well, I don't understand, I'm trying to find it here. It basically says that the commission is not to get involved in the operation of the commission.
The day-to-day administration,
Just the day-to-day administration.
filing, billing, things like that. That's what the administration stuff is.
Okay.
Which we shouldn't get involved in.
Generally
Shouldn't
agreed.
be getting involved in that, right.
Is that clarified for you a little bit?
So we shouldn't get involved in billing.
No, Bob does the billing.
We get involved in the budget.
Bob sends out billing. Bob sends out letters.
We're pretty
That'd be like,
involved in the billing.
that'd be like if you were gonna send a letter to somebody for a grease trap compliance issue. We wouldn't, the commissioners wouldn't send it. It's an administrative duty that Bob would do.
I think we do get involved in
We
helping
vote to
Barb.
send it, but we don't send it
I don't think
ourselves.
this really changes that much from what it already says. It still is going to cause people to have question about what is day-to-day and what is not day-to-day.
Right, yeah.
So
that's-
I don't think this sentence really changes one of the issues that have been ongoing about what's day-to-day and what's not day-to-day. So I guess based on that, I don't have a problem with this change.
Yeah, I agree with you. I don't think this adds a lot to the areas it adds anything to clarify any of the areas that we struggle with. So I'm not sure why we're adding something, yet another item that really isn't, according to people who've commented, not really changing anything. So I'm not sure why we're adding stuff that doesn't actually change
I
anything.
think it's better worded and more clearly worded.
Then what? We're not
I will-
removing anything.
I do agree that it doesn't clarify the questions that we've been having. But I will also comment that Bob did come to the meeting on 12/5 and did ask for inputs and things like that to be done by January or February. And as far as I recall, we did not have that discussion. And maybe that's my fault for not putting it on the agenda. So they kind of went with that theme of what they just said, is in other commission
It's
type
also-
areas as
It
well.
runs throughout.
Yeah, the
runs
cemetery,
throughout.
I believe it says
It's in the
something similar.
cemetery, it's in the, because I looked at the
Parks
whole
Commission, I
thing. Yeah.
think, yeah.
So I think it's more commissions that have policy that kind of rings throughout. So I'm not disagreeing that it doesn't clarify what our discussions are, but that's what the whole point of this agenda is. So I'm going to keep going.
Yep.
And we can discuss what we want to add, and we can bring it to the committee.
So was that was that both sentences,
Nope,
Mr. Chairman?
there's
or
more.
Just the first one?
The second, it is the intention of this provision that the commissioners shall act only through the adoption of broad policy guidelines. So that first major change there, that's the whole thing.
So I also don't understand that one. Matter of fact, that one sounds like it could be construed to be very constraining, that we will only act through policy. We act through a lot of things other than policy. We're responsible for regulations. That's not a policy. We act through regulations and procedures.
Well, I think that we can add to that, if it's allowed, to say that we act through policy, comma, budget, because we also do budget, comma, and regulations.
Well, if we're going to, to your point, Mr. Chairman, we were asked in January for inputs. The commission, no one seemed interested in changing anything. So we never made an input, and no one asked for it to be on the agenda to make input. So, our message was we weren't anxious to see change. But if we're going to change, and, we can start changing the language here, there are other things, because one of the themes of the Charter Review Committee was to try to make things consistent. And if that's the case, there are things in other commissions that we should get added to ours, and regulations is one of them. There's I don't know the commission right here, but there's a commission where it very clearly says they're responsible for regulations. So we might want to go through and look at, in its entirety, what the other commissions and boards have in them, and see if there's other things that we want to make common that we do now. Not to change what we're doing. I don't think anybody's intending to change our overall scope of responsibilities, but if the effort is to clarify and make consistent, there are things that we do that are not specifically identified here, but are specifically identified in other commissions and other boards. And I would suggest that we pull them. So, and we can't do that tonight, but we could do that.
No, I suggest everybody go home and really dig into this.
yeah,
And not send it to everybody, obviously.
No.
Joe, it appears that I have lost it in my email. I had a problem with my email where I couldn't receive more emails because I was overloaded, so I deleted a bunch, and it appears I've accidentally deleted it. Would you mind resending it to me?
Give me 1 second, and I can definitely do that. It's
Appreciate
in
that.
Tuesday's package, right? Barb?
Yeah. Friday. No, it was not in Tuesday's packet. It was
The
the
em-
full chart.
no, the
Yeah,
full-
the full thing.
Oh, the full chart. Oh, the link that I sent out.
Yes.
Yeah, I can do that too.
Thank you very much. I'm sorry, I lost it.
Now that I've been a pain in the butt to the charter review committee, if I search charter, I get a million emails. Hold on, I can find it.
The issue is, if everyone is going back to discuss it, that they are holding a hearing on April 5th. And your next meeting is not until April 10th, so you'd have to go to a hearing as, just with your individual input.
Well, I
But we could go to a charter
suggest we
committee
post a
meeting.
meeting for that hearing to cover ourselves.
I wouldn't, well, hold on, let's
I hate to see us go there and everybody has a different idea and we stand.
Yeah, no, we need to
in line.
clarify, and I might have to call a meeting in between these ones. I know we try and steer away from doing that, but we need to do it.
Speak with one voice.
So I'm planning on possibly calling a special meeting for Tuesday, next Tuesday, the 2nd, to kind of go over the stuff.
And did you send me that link?
I just did.
Okay, it may not come through here. Got it, thank you.
Yeah, no problem.
I think that's a great idea, Mr. Chairman, because there are a number of things in here. I mean, there's even some things up that we've kind of went past with the Board of Selectmen that have been added that I think create confusion, certainly in my
But we're
mind.
So that
going
part,
over the
so that part would be for the
But
public
they create
hearing.
confusion here because they seem to be adding things
Well, let's keep
that
going.
would say the Board of Selectmen.
Before we go
would
on,
have control.
just want to comment about the one sentence. I haven't gone through and read the entire document, but the sentence that is, "It is the intention of this provision that the commissioners shall act only through the adoption of broad policy guidelines." It almost seems like the insertion of an opinion or an editorial comment, so I don't know if that's throughout the rest of the document or not, so that's my only comment right now.
Okay. So I'm going to keep going, and the next change is to the day-to-day operation, care, and maintenance of the sanitary sewers shall be under the supervision of the town manager. I believe that's supposed to be manager. And the change is, comma, who may delegate such authority. I think that's just to add that it's not, obviously, Heather's not the one doing the day-to-day stuff. She delegated it to Jack. I'm okay with that part. It doesn't really, I know we all talked about clearing up what day-to-day means, but the next change is about appointments of Barb, or a business manager in general. The appointment of, I'm just going to read the entire thing. The appointment of a sewer business manager by the town manager shall become effective on the 15th day following the day on which notice of the appointment is filed with the Board of Sewer Commissioners, unless the Board of Sewer Commissioners shall, within that period, and by a majority vote of all of its members, reject such appointment or has sooner voted to ratify it. The word ratify was changed from affirm. That's the entire charter. They changed affirm to ratify. The town manager, this last sentence was added. The town manager will be responsible for supervision, evaluation, and all personnel actions relating to this position, meaning that she's going to oversee Barb, which I don't know if that takes away from Jack or not, because the other one says that you could delegate it, but this one actually doesn't.
Yeah, that's exactly was my question, Joe. 'Cause I don't have a problem if it's saying that the town manager will become Barb's supervisor. That, in my opinion, I would strongly support that because I think it
Maybe it takes
elevates
Barb out of
that.
the
I mean,
middle sometimes.
Barb's in a very responsible position, and I think that position should report. It should be supervised by the town manager, and it would remove a lot of these, caught in between things and all this stuff. So I hope that's what it means.
Hold on one section.
Okay, but it's just my understanding that she can delegate at any moment in time to anyone she sees fit to delegate.
Well, the funny thing is, up here, they say who may delegate such authority, and down here, they don't say who may delegate such
I know,
authority.
but I still think that if you check on it, I think that she still has the authority to
And
delegate.
it might be down here in the town manager changes, and you might be right.
Just to give you, Barb Deversol, Chairman of the Charter Review Committee, just to give you a couple of clarifying things, and I think Carl's comment was good, and I'm glad you're going to have a meeting if you can. The section about the provided, however, nothing will be construed, and it's the intention of this provision. That is lifted directly from the Board of Selectmen section and put into the sewer, the park, and cemetery to somewhat clear things. As Carl noted, the cemetery does have a section that says they have the sole authority to make regulations relating to that. My assumption is that that's included within the general powers, but if you want to add that, that'd be fine to add that consistency. The section about who may delegate such authority, we technically don't need to have that because the town manager in the town manager's duty always has the ability to delegate her
That's right.
authority.
That's right.
So that's sort of superfluous. I'm expecting town council, when town council comes back with a review, that he may say you don't need to have that there.
Okay.
And then as far as the supervision, this clause was added within the planning director under the planning board and here, because those positions, we are trying to clarify, so you have one person's doing the supervision to make it consistent on that part. So that's.
Does it actually make it so Barb actually does report to Heather instead of Jack? Or she could still say it's Jack?
She could still say it's Jack.
Right.
But what
it's
is-
ultimately, the town manager is ultimately responsible for the supervision.
What is the intention of the commission? What's the recommended of the Charter Review Commission, though, in doing that, that they do report to the town manager?
Yeah, town manager.
That is the,
That's the intention.
That's
But the
intention.
town manager has the authority to do it differently.
they can, but.
So, Bob, now that you're up here, what's the drop dead date if we wanted to, well, first of all, when's your next meeting? I know you have a public hearing on
We
the
don't
5th,
have, we will be posting a meeting the same night as the public hearing.
so you don't have one yet?
No, because we voted to adopt this, vote to recommend this to the town to go to public hearing. We're going to have a meeting the same night as the public hearing with the, I'm asking people to get comments in advance so that I can tee up votes after the public hearing. So we will take all the public comments that come in writing and have those as potential votes, and whatever comments come from the public on the various topics, we would try to have the votes there. The selectmen have to post the warrant, and the warrant article doesn't have the entire language, but it has the subject of the topics, and it refers to a final report. So we have to have the final report available before it gets posted, not when the selectmen sign it. It actually is when it's posted and sent out to the public. So therefore, that's why we're asking for as much information in advance that we can get to town council to review whether it's allowed or not, and try to get the appropriate wording.
So if I have a meeting, if I call a meeting for Tuesday, which I plan on doing, and we have our own changes we want to make, we can email them to you,
Yeah, and that will be added to the agenda.
and that'll be added to the agenda for a vote within your committee, correct? That's how the whole thing is
That's
working. And what's the drop dead date of actual, so there's a meeting before or after the public hearing?
After.
Okay, so you're going to take everyone's comments and vote on each one of them?
If we have information in advance, I will send that to the commission in advance so they'll be prepared.
Okay.
The sewer commission has sent the following things, somebody else has sent this, here's the summary of all the topics. They won't be surprised of the various topics that people have comments on. There were some votes we took that I expect will hold, other votes we took that will be reconsidered because they said, well, here's how I feel, but we want to get the input of the public, so.
Okay. So we can do that. So this
Yeah.
isn't, obviously it's a draft, so obviously it's not set in stone.
Yeah.
So, Mr. Chairman, I'm glad you mentioned, Bob, because the words, as you said, in the ones we discussed before, particularly it is the intention of this provision that the commission shall act only through the adoption of a broad policy guidelines, that's exactly in the Board of Selectmen.
That's correct.
So I don't quite understand, even with the Board of Selectmen, how to interpret that, because clearly the Board of Selectmen act in other ways than through policy.
And I think it's been inappropriate. And my personal example of the selectmen picking trash bags is something that we should not do. We should delegate that to the town manager. We should have guidelines to say we want trash bags that are stronger, we want trash bags that are going to be other things like that, but we shouldn't be doing that level.
Yeah.
And I think that's something that we've gone up and come back, and so we're learning this process as well.
So what you feel and what the Board of Selectmen do are two different things at the moment. I would take particularly the example of the Board of Selectmen are the road commissioners. And as road commissioners, you just prepared and got past this road management program, which not only specified the program, it specified which streets would be involved, how much money would be involved. So I think that's a little bit more than acting as policy setters.
So road commissioners are separate authority from Board of Selectmen, so I can't speak specifically of whether we were acting as selectmen or we were acting as sewer commission, as road commissioners, but I would bring us to the road opening policy. So we go to that, we adopted the road maintenance program with the roads in there, but we did not insert the roads. We adopted the policy as presented by the town manager and the DPW. So if we went in and said, we want you to take Lancaster Ave and move it from here to here, I think that's going beyond our...
So why isn't one of the modifications to the charter then to add the road commissioners to this and to tell them that they can't act anything other than policy?
I think that's a good legitimate question, that we need to say whether in Board of Selectmen, whether acting as road commissioners
I would
or
send
not.
that to Bob, to the public, for the public hearing. Now, obviously not for the sewer commission,
that's
but...
right.
Yeah, so I'm just trying to understand, because to say you only act through
that's a good
policy
point.
is extremely, through policy,
So here's what I'd like to do. I'd like to
Thank you.
call the meeting, thank you.
Yep, listen.
I'd like to call the meeting for the second. I'll send out an official notice of it. and really have things prepared. Don't send them to everybody. Just bring them.
Can I get a clarification? We're not doing the whole charter, we're doing the sewer commission portion of the charter.
If you have changes outside the sewer commission, bring it to the public hearing. You can send it to Bob on
But
your
we're
own.
not gonna discuss that
but we're
in
not-
our
I'm not
meeting.
discussing that in our meeting. Our meeting is going to be specific to what is now called 313, but in the charter, without the draft, without the changes, is actually 314. So as it
But
stands, it's
Mr.
314.
Chairman, there are things elsewhere in this charter that affect us.
So if they affect us specifically?
Yes.
Then we can
Yeah.
bring it up.
Minutes, there are things in here about minutes.
So again,
So,
come up with some stuff.
okay.
And
So I
we'll-
just,
we'll
we're not
talk
going to
about it
restrict to
there.
that specific section.
If
there's other things that
anything
affect
that
us.
does actually affect the sewer
Great.
commission, which,
So what page is the sewer commission actually have?
so it starts on 11 and it goes into 12.
Okay, thank you.
There's not a whole lot of changes, but we need to talk about them.
Got it.
I don't necessarily agree with all of them either, so I want to talk about it. And this is our opportunity to add clarifications to day-to-day and things like that that we've been having a lot of discussions about. So, yes.
One other thing that you may want to consider, which is what I discussed in January, was that in the language that has not been proposed to be changed, let's see.
Where are we, Bob?
So powers
Page
and
12.
duties, the Board of Sewer Commissioners shall make careful studies of resources, possibly needs of the town as they relate to availability of sanitary sewers, and shall make plans for the installation of a system of sanitary sewers and for maintenance. Shall develop a comprehensive and master plan for town-wide system of sanitary sewers. So the question becomes, I think that at one point, the town voted, after the charter was there, to pull back and not sewer the entire town.
All right, so we should,
So you may want to finesse that to say, to make careful studies of what appropriate places of the town should be sewered, as opposed to this. I mean, the fact is, if it stays, you're not going to sewer the whole town because the town's not going to vote it. But if you want to look at what your message to future sewer commissioners is, what, this is your opportunity to do that.
Right.
good point.
Thank you, Bob. So anyway, we're gonna move on from this agenda item. Please come up with some stuff. I'll just say now that I'm gonna call the meeting for Tuesday. I believe that's the
Third
third.
time?
Same time, 6:30.
Okay.
We'll have to, upon availability at the DPW building, see if it's available or not, Bob, if you could. Does anybody,
I don't know if I can make it, but if I send you my changes, would that be sufficient?
send them to Barb?
I'll send them to Barb, not to you, send them to Barb.
Yeah, send them to Barb. Just, I don't know if it's a problem or
What
not,
else is
but
on the agenda for April 5th besides the charter?
that's gonna be, on April 3rd. And that'll be it.
That'll be it?
Yeah, it's the 3rd.
Can I possibly ask if we could start a little later then, at 7, because it would make it easier for me?
I'm
if
okay with
there's-
that.
If there's only one topic on the agenda?
Yep,
I'm fine with
I'm fine with 7. Troy, you good with that? Carl, you good with that?
Yeah.
All right,
Thank you, appreciate that. That makes
Bob,
it
can you
more
get that?
likely that I can get there.
just send me the agenda Thursday and we'll, same
We're
process.
talking about-
I'll ignore you, you'll call my cell phone, then I'll approve it, same process as usual. All right.
We're talking 1 week from today.
1 week from today, yes, at the DPW, we just gotta make, Barb will obviously have to make sure it's available and things like that. I know this room won't be available, so.
I think you said it before, but I'd like to highlight if the commissioners could look at the other boards and commissions.
If it directly
and see
affects this,
what they think.
if it directly affects the
Yeah, if it's-
sewer commission, then yeah.
relates to it, yeah.
If it's just things that don't affect it, then yeah. I mean, if you have issues elsewhere, public hearing is the 5th, and bring it there.
Yeah, no, I mean to see if there's things in other places that we should consider putting in ours.
Absolutely.
That's
Yeah,
all.
take whatever changes you think are necessary. We'll talk about all of them. I mean, we might not agree on every single one of them. And then what we can do is we can take those changes, summarize them. I can send them to Bob. Bob can give them to the charter committee. And we go on. And we'll see, and then they vote on them. I mean, it's not guaranteed that our changes make it in there either way. That's the process. Good, okay, good, yeah, that was good. Order of assessment, 3 Rogers Way. You gonna sign some stuff?
Yes, it's just a signature. Building 2 has gone in. We have collected privilege fees. We did the same thing for Building 1. In order to collect the fees, the treasurer needs this document signed. It is for the full amount of privilege fees, like $199,000, but that's spread over 20 years. So it is the full assessment for those properties on Rogers Way.
Okay.
Did you make this date change?
Oh, here we go with John,
This is always silent.
checking grammar. He's Carlizing the,
Yes.
Bad influence.
he's Carl-lucking it.
That was, it was originally going to be.
Taking the heat off me.
It was originally going to be the March 13th meeting, and we were not here. Current date is on there, right? March 27th, I think.
We're moving along here. We got 8:40. Never mind. No, we're not. It's been 2 hours. Time flying, I guess.
I mean,
Anything before 9 is good.
We still have to do executive session.
Yes, we do. Are you holding up?
time for you to go.
You water or something?
John did
we
point
get some
out
water?
that it's, oops, sorry. It is still dated March 13th. It was coming before you for signature on the 13th, so
Do you want to initial?
I think shouldn't everybody? Yeah, so everybody signing should initial that date. It's, yeah.
Sorry, Barb.
That's all right. I'm glad you.
Good job, John. They keep Barb on her toes. As that goes around, I'm going to just talk briefly, member agenda inputs for future meetings. I want financial policy on there probably sooner rather than later, not for next week's special meeting, but maybe for the meeting after that, we can start talking about
About what?
financial policy.
Financial policies.
Not to come up with one that night, but just to kind of start bullet pointing some stuff. 'Cause to John's point, it should probably happen sooner rather than later.
Maybe come up with the general strategy.
Sure. Yeah, and if anybody has anything, please bring it. Ideas, suggestions, bring it to the meeting. We'll talk about it.
Is that next week or the following week?
No, next week is just going to be the charter review. It'll be the regular scheduled meeting, if you can. And then maybe I'll get rid of it if it's too loaded. We'll see. I don't know what the exact agenda is right now, but anybody else have any agenda inputs for future meetings other than that?
Not that I wish to bring this up, but we haven't heard about grease traps in forever. I was wondering.
You missed grease traps.
Are we all current and everyone?
They're abiding.
They're abiding. If they're not, Barb just sends the letters and stuff. I think we gave her that authorization to do it. Yeah, it's nice, right?
Had an impact.
I know, interesting.
Well,
How that
actually,
worked out.
Mr. Chairman, along the line of my short list, grease trap was one, but focused on the grease, well, two things on the grease trap I think we need to talk about. One is I'd like to talk about the schools.
So you want to add school to grease trap?
Well, they are on the grease trap.
No, you want to
Yeah.
add that to the agenda.
Yeah, well, in the agenda, just rather than just be vague and, I would like to understand the schools, where they are with their new interceptor, and see if they're pumping reports and, it's a new customer kind of, just to see that. It shouldn't take long. But also, when we're going to get the letters out for everybody for the FY19, because we always run a little bit late, and then we have to have it be after the date we'd like, so.
So you want those two items?
I think, yeah, just to get a schedule on that, because I
Okay.
think they got to go in April.
All right, so we'll add those.
Billing, I would really like to get in there. We've made some good progress on billing. We've got, I think, a very good short-term toe in the water proposal, short money. We can get what we need, so I'd like to have that on there, because I think we're ready to
add that.
to debate and hopefully pull the trigger on that.
The goal here wasn't to fill the agenda. When I said that it might not be that full, I wasn't trying to open it to fill it.
No, but that's pretty timely, because if we want,
That's
if we
fine.
do pull the trigger,
So billing-
we have time to get it
School.
implemented by the beginning of the fiscal year.
Billing,
Grease trap.
Grease trap.
School in the letter.
what else? Not guaranteed they're all going to be the next.
Yeah, no, well, so if it's not going to be all, I'll give them all to you then.
No, you don't have to do that either.
Maintenance, I'm still trying to get the maintenance plan, which again is
Maintenance
just a plan to do it, get a scope of work and so forth. Irrigation meters, I think that's very timely because the fiscal year's here and we've,
I would say put irrigation meters at the top of the
we
list.
need to
if
look
we
at
can't
that.
do all of these at
need
once.
to look at that policy and.
Yeah, I'll take a look at what it says.
You know, what we're going to do. At some point, I think we should get, especially with our open meeting law things here, I think we should get an update on where we are with our minutes, our outstanding minutes, the historic minutes that we're, delinquent on, that we're trying to catch up on. Just,
thought
where are we?
The ones from the open meeting law complaint were already done.
I don't think we've I don't think we've caught up all of the past minutes.
I'm going to talk to council on what needs
So we
to
need to,
Okay.
unless we're given some
So you
special
you
dispensation.
take that action and,
No.
and figure out what minutes need to go on the agendas, like you always do, and go from there. Okay. Anybody else?
That's it.
Good, good. Public comment from the board? Public comment from the public?
I'll take the opportunity to, since you're untelevised, to encourage people to come to the Charter Review Committee hearing on Thursday, April 5th at 7 PM here at Town Hall. If you have any comments, you can get them to us, care of the town manager at P.O. Box 135, Lunenburg, to get your comments in advance so we can take consideration of them. But you're also welcome to come to the public hearing as well. The charter and the report and the hearing notice are on the town's website. Thank you.
Thank you, Bob. Okay, so this was to end the regular meeting, and then we're going to go into executive session. Do I need to request the motion for executive session first? Bob, is that what you wrote down here?
It should be,
I have to read this, right?
yeah.
Request motion to enter into executive session for the Highfield Village Agreement under MGL Chapter 30A, Section 21A3, to discuss litigation strategy regarding Highfield Village and the sewer allotment and payment agreement between the Sewer Commission and Robert A. Leverone, Lunenburg Nominee Trust. Based on this chairman's declaration, the discussion in an open meeting may have a detrimental effect on the litigating position of the Sewer Commission, with the commission not to return to open meeting at the conclusion of the executive session.
So moved.
Second.
Any further discussion? All in favor?
I
Aye.
think we have to take a roll call.
Oh, roll call to go into
Also, we need
executive
to
session.
go off there for the executive session.
Do we do roll call first?
Okay,
Yeah.
Joe Spanderson.
thank you.
Carl Luck.
Joan
Aye.
Pease.
Troy Daniels.
John Reynolds?
Okay, we will need to go off air.